The Trump administration is citing the 1989 Panama operation as precedent for capturing Venezuela's Nicolas Maduro. But does that comparison hold up legally? Here's what matters. In Panama, the U.S. had specific justifications that don't exist in Venezuela. Panama's legislature declared war on the U.S. A Marine was killed at a roadblock. American citizens were being detained and abused. The U.S. had treaty obligations regarding the Panama Canal. Those aren't abstract legal theories. They're concrete triggers under international law. Venezuela? None of that applies. No declaration of war, no dead service members, no treaty obligations, just an arrest warrant from 2020. And the administration's claim that Article 2 lets them protect personnel executing it. The administration argues Maduro isn't a legitimate head of state, so normal sovereignty rules don't apply. But here's the problem. While the U.S. stopped recognizing Maduro in 2019, he's been the internationally recognized leader of Venezuela for years. With Noriega, the U.S. recognized opposition leader Guillermo Endara before the invasion even started. That distinction matters in international law. Scale matters too. Panama was a full invasion, 27,000 troops, weeks of fighting. Venezuela was a surgical Delta Force raid lasting hours. That makes it harder to justify under defensive doctrines. The domestic legal argument relies on the Kerr doctrine. Essentially, if we can physically get you into a courtroom, courts can try you, regardless of how you got there. That worked for Noriega. But Columbia law professor Matthew Waxman calls the Venezuela legal basis very murky, and even Trump's own chief of staff previously told Vanity Fair that strikes on Venezuela would require congressional approval. The administration notified Congress only after the operation began. Democrats are calling it illegal. The Noriega comparison gives some legal cover, but the circumstances are different enough that this will face serious constitutional and international law challenges.